All right, welcome back to the Judicial Proceedings Committee. Today is Wednesday, April 8th, 2026. We are operating on voting list number 23. Before we dive into the voting list, we're going to entertain House Bill 956, the hearing which is concluded. There's a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. House Bill 956 passes unanimously. Thank you, Delegate Rosenberg. Awesome. All right. We're now going to go on to, this is not on the, this is Senate Bill, I think this is Jamie 334?
Yes,
So this is a concur, not concur.
yes.
This is Senate Bill 334.
You don't have it, it's not
It's
on
not
the
on the
voting
list.
It's-
Just look it up. It's the
it's-
Glock switch bill.
The block switch,
Yeah.
is that our bill? Where did we get the block switch?
Because we have to not concur.
Was it our bill?
Thank you, Mr. Chair.
I thought first voted against that.
So Senate Bill 334 is machine gun convertible pistols. The House amendments to the bill struck a requirement that the state police promulgate a list of the firearms that are covered by the bill specifically, and let me just get to the language here. There's a requirement on page 7 that the Department of State Police shall adopt regulations to implement this section, including publishing a list of prohibited machine gun convertible pistols. The amendment adopted by the House turned that back into a discretionary, so it made it a
So
may.
they changed it from a may to a shall, and we had a,
No,
sorry, they
it's
changed it
shall.
from a shall to may. Shall to may. So we are not going to concur. We're going to go with the Senate version. That's the motion. Is everyone okay with that? All right. Now just roll the bill on the same vote count that we recorded before as left.
Let's not do that. Let's.
You want to roll call? Or you-
I'm still, my computer's still pulling up. I'm just trying to, Jamie, can you just explain one more time the part about what is the,
There was a provision that the Senate added that would have, let me back it up. As the bill originally came in, the state police had discretion to adopt regulations to implement the bill's requirements. And those regulations could include publishing a list of prohibited machine gun convertible pistols. What the Senate did was turn that into a mandatory requirement for state police so that they would have to promulgate regulations, including publishing a list of prohibited machine gun convertible pistols. And what the House amendments did is shifted it back to how the bill came in introduced. It made it a may instead of a shall.
so they made it consistent with HB 577 then?
As introduced, yes.
All right, just 1 second, sorry.
Well, while you're waiting on your question.
made, I think, had your suggestions part of the dialogue we had, just making sure there was clarity as to what was on, they had to publish, I think, clarity as to what was on.
May adopt regulations to implement this section, which means,
We're doing it shall.
so I guess my question is from my perspective, I think I would rather it be the may. Because if they don't, then
Don't you want them to have to?
I think you all want them to have to. So if we're talking about adopting regulations to implement this section, including publishing a list of prohibited, if they don't publish a list, then what would they be prohibited? Because they have a list.
So the requirements of the act would still apply. It's just that what state police was providing there was an actual list of what it applies to. But regardless of whether they publish that list,
It would still be.
anything
Okay.
with a cruciform trigger is the trigger bar and
Yeah, so,
that meets the
okay.
other requirements.
Then in that respect, yes, I agree. Thank you.
So I'm just trying to understand the policy debate and the import of the may and shall here. So globally, the bill describes generally a type of, handgun that can easily convertible, or just convertible, let's just say, right? So that exists, regardless of what we say with the state police, that would be prohibited. Then we have a section that says state police, because that's the statute. Then we ask the state police to promulgate regulations consistent with that ban. And in addition to that, and I'm trying to think what kind of regulations they might, pass or use, but in addition to whatever regulations they do create, we are mandating or permissively suggesting they also create a list of specific handguns, I guess by name. So you wouldn't go by description. You'd call the Glock something something, the Remy something something gun. Right? Is that, I don't know what these lists look like. I don't know the detail of it, but let me just continue. So then they would give a list. One of my thought processes is, because I'm not familiar with this area of the law, is you could have a bill that is descriptive and then a list that is not descriptive, and they could be in conflict from time to time, and I don't know what would supersede. In other words, the list could be deficient in capturing all the types of guns that fit the description, or the list could have a gun that does not fit the description, and I don't know what you do if that ever occurs with an inherent conflict between a list and a description of something. So this probably is well-established law, but I don't know it, and so I don't know what the advantages and disadvantages of may and shall for this particular list and why we do it as a matter of policy.
If the requirements of the law stipulate, what is and was not permitted, you would want to have clarity from MSP on this list as to what is permitted and what is not permitted, because the requirements of the law are going to apply no matter what. So if it's a may, that does not provide clarity and certainty that a list of prohibited firearms is going to be published. And so you would want it to be shall, so that everyone is on notice, because the requirements of the law apply no matter what. And so the shall is very important in this circumstance, so that people have the information they need not to run afoul of the law that we're about to pass.
So for you, it's augmenting, supplementing, enhancing, and clarifying. It could not be in tension with one another, that the list and the description could be different in a way that could be challenged.
That's correct. So
okay.
if you're going to put in a law with criminal and civil penalties, you certainly want people to have clarity as to what that law is.
So can I ask you, here's a question. So here's a technical question. The list exists, then a gun that's not on the list, but arguably fits the description, it's not on the list. Where does that fall if it's challenged, so that it says the Glock, 2030, which didn't even exist, last week, but it came out now and it's not on the list? How does the descriptor and the list work together in that circumstance? And that's why I'm asking the question, actually. I appreciate what you told me about clarity. I understood it, actually. That's really not the heart of my question.
So I think it's a question of, if I understand it, who's challenging it? Are we saying that,
I don't think it matters.
Well, I kind of do. I think in the case of a criminal case, if charges were brought against somebody, let's say for your example of the
Let's get out of the
fictional.
criminal, just say it's challenged for.
Sure. Well, go down the route of the fictional Glock 2030, scenario here.
Probably gonna come up now.
And say that it has a cruciform trigger bar, it meets all the other requirements of the bill, and it would be one of these things that is prohibited from being sold in the state. And but it's not on the list. But let's say a dealer working off of the list goes ahead and sells it, and
Because maybe that, because because the descriptor is not as accessible to ordinary humans as that list is.
right. I mean, the bill doesn't say that this list supersedes, any other interpretation. I think it comes down to an argument and a decision for the court.
I thought maybe it was settled law, Jamie. I thought you would tell me, look, we do lists and we do this, and this is how the courts interpret it.
Now, I mean, I think that you could make an argument that the regulations piece is MSP, publishing regulations that interpret, what the law is, and in that case, I think that would be persuasive as far as, well, we have this regulation that's interpreting it, and in every other aspect of law, when the state has come in or an agency comes in and says, we are interpreting this, typically they get deference to their interpretation. I think you could make that argument, but I can't give you, I don't know that I can give you exactly the 100% answer
One of the reasons I
on
bring
it.
it up is I know that the opponents of this bill, who are very intelligent, have kind of brought up that we really don't a lot of us are talking about these guns in ways that we show a lot of, and I mean this in the kindest way, ignorance about guns, right? So we say things that are just not accurate or understood. And I understand that we did our very best to describe the gun, but I can imagine that the mechanics of how the gun works and the label for the various parts are also can be easily separated. You call it cruciform, but there could be a mechanism that could probably do something extraordinarily similar, but yet not have that name. So that's where I get into the idea that you could get into a tension between them. And I just thought, and I'll stop my questioning, I just thought that this was well-established law, that this has come up in either in guns or some other circumstance where we would know how these things get resolved. But I think what you're saying is no. That's the bottom line. I don't mean to hijack the meeting, but
my sense is no. If, obviously, if you'd like, I would be happy to go to the AG's office and get a little bit more clarification.
I'm just bringing it up now. Thank you. All right, thank you, Mr. Chairman.
Thank you, Mr. Chair. So in listening to my colleague, I just wanted to point out, obviously, these Glock switches are already illegal. They're already a felony to possess, to put onto the pistol. But we've created a new, and correct me if I'm wrong, counsel, but we're creating a new definition. Like we've got a new phrase, machine gun convertible pistol.
Correct.
Because I've never heard that before until this year. Machine gun convertible pistol, and I'll put it in quotes because it's on quotes on the legislative matter. So I guess my question is, because you can convert any semi-automatic handgun, whether it be striker fire, hammer fire, or cruciform trigger bar, to a fully automatic firearm.
Right.
Fair?
Yeah, that's my understanding.
Yeah. So I guess my question is because this is so detailed and we've created this new term, machine gun convertible pistol, if the manufacturer just says we don't call them cruciform trigger bars anymore and they call it a loop-de-doo flat switch, where are we?
I guess to answer that, let me.
Because we don't have a definition of a cruciform trigger bar.
Cruciform trigger bar is defined in the bill as a component in a semi-automatic pistol that serves as a link between the trigger and the firing pin.
Correct.
And has a sear incorporated into a cross-shaped surface. So.
If we change the definition, if we change the term inside the firearm,
right, to
a loop-de-doo flat switch,
right, or a trigger bar, loop-de-doo. Let's go.
Or just drop the cruciform trigger bar. Just call it a trigger bar.
If
as written,
right,
would we, if say Glock comes out and says, you know what, you're right, Marilyn, cruciform was a bad word. We're going to strike that from all of our literature, and we're just going to call it a trigger bar.
Right.
Are we in violation? Would anyone then be in violation with this as written?
It doesn't change how the law views it. You have the term that's in quotes, and that's at page 2, line 25, and following. So if it meets these two requirements, that it serves as a link between the trigger and the firing pin, and it has a sear incorporated into a cross-shaped surface, then no matter what Glock calls it, state law will consider it to be a cruciform trigger bar.
Yeah, I don't know if I fully agree with that, but I think that the way that the language is with and again, it's important to be on the record. I think that the way that the language is and the way that we are, we're making definitions as we go here. We're common household tool. We've created it very narrow to what a common household tool is. And then we've added in this cruciform trigger bar. And again, this is just a very slippery slope when we're talking about the Second Amendment. We're talking about things that are easily converted, and it's already illegal. It's already a felony. And then it also serves as, where does this stop? Because, again, you can put nitrous in a car. It's illegal. The car itself's not. But when you put the nitrous in it and drive with it, it's illegal. And it becomes much more dangerous. But we're not out there, and I'm not having to, I don't mean to have this
No, I hear you.
colloquy with you.
Let's do this. Let's at least either concur, not concur. The motion is not to concur. It's been seconded. Is everyone okay being recorded in the affirmative? All right, let's then, Senator, this is on the concur, not concur.
Not concur.
Yeah. Yeah.
I'm just going to be
Down on, yeah, I hear you.
But I think it's unconstitutional.
Yeah. That's consistent.
I'll be down.
So now there's a motion for favorable on the not concur.
No.
Sorry.
It's good.
Oh,
It's just the motion is not.
It's the motion, though, the motion. All right, now we're going to move on to voting list number 23, which is a consent calendar. Can everyone take a look at the consent calendar? So voting list number 23. The one pager. All right, what's your flavor? This is voting list number 23. It's a consent calendar. There's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative on the consent calendar number 23? Yes. Senator James.
Just so I could make sure I know what I'm doing. These are all bills that we passed, got cross files, and we all supported them.
These are bills that passed unanimously on the Senate floor.
Thank you. Okay, thank you.
And are identical.
And
to
they're
the Senate
identical to
version.
to the Senate cross-file. All right, so. I wish. All right, all right. So now we're going to go on to voting list number 18. And we're going to start off with House Bill 1292, which is on the last page of voting list 18, and that's Shamari.
House Bill 1292 requires the standards established by the Maryland Statewide Organization for Child Advocacy Centers to require, one, an individual employed by or contracted with a child advocacy center providing mental health services as defined by national accreditation standards to be licensed or certified by the appropriate health occupations board and services within the scope of the provider's license certification. And two, each child advocacy center to establish a specified continuity of care plan. Each child advocacy center must report a complaint resulting in a finding by Child Protective Services that is based on the standards to the Governor's Office of Crime Prevention and Policy for referral to the Attorney General for investigation and further action if necessary. GOCAP may issue a grant to assist the Child Advocacy Center with technical assistance to implement standards. By June 1st each year, beginning 2028, GOCAP must publish specified information on the department's website for the immediately preceding year. The bill takes effect July 1st, 2026.
This bill's been before the General Assembly for several years. This is the first time I've seen all of the stakeholders come together in agreement. This bill passed the House and the committee unanimously. I would like to make a motion for favorable. Just second. Is everyone okay being recorded in the affirmative? You're gonna hold this one? House Bill 1292 passes unanimously. House Bill 980, which is on the second to last page.
House Bill 980 prohibits the social services administration within the Department of Human Services in the administration of its out-of-home placement program from allowing the placement of a child in an unlicensed setting. In addition, the bill makes numerous alterations to statutory provisions related to guardianships, including, one, the establishment of procedures requiring adults in the home of an individual whom the juvenile court has appointed as guardian to obtain criminal history records checks, and two, requiring a local department to file a petition for the review of a guardianship with the juvenile court if the local department deems it to be in the child's best interest based on review of information. The bill also establishes the Office of Child Welfare Ombudsman in the Office of the Attorney General to investigate and determine whether, one, the needs of children and families under the jurisdiction of DHS or a local department are being met in compliance with state law, and two, the rights of children and families are being upheld, and three, the children are not being abused or neglected. No amendments.
All right, there's been a motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. House Bill 980 passes unanimously. Yep.
Crossfile?
SB 996.
Can we move that? Can we amend it, put it in the same posture and move that as well? It's Senator Zucker.
Yeah. So moved. Hold on. We just got it. We usually do that.
Sorry?
We usually do pair them and run them parallel. We just got that out of rules, so do we have it in our possession?
Yeah, I think I can add it.
Thank you for saying that. Capital Budget Subcommittee Chair. All right, so we're going to move, what's the Senate bill?
996.
All right, so we're going to move Senate Bill 996 in tandem. It's the Senate cross-file. Is everyone okay being recorded in the affirmative? Yes. Do we have to conform? Are they a different posture?
Hold on, let me just check, double check. Yes, thank you. We do need to conform to the House bill.
Motion is to conform.
Second.
Is everyone okay being recorded in the affirmative? Now the bill's before you. We're done. Passes unanimously, okay. All right. The out-of-state enforcement, is that Addison? All right, we'll do 212 first. House Bill 212, is that the enforcement? That's your possible, right?
212?
Yeah.
Is it 212?
Yeah.
The other one.
We can move 107.
All right, what's gonna do? All right, we're gonna do 107, Josh, right? 107?
House Bill 107 is the cross-file to Senate Bill 366. The bill requires an intelligent speed assistance pilot program to be established by the Motor Vehicle Administration. So the Senate bill has already moved over to the House. You have on your desk a reprint of the Senate bill, which is Senate Bill 366, amendment number 993823/1. This is where I understand kind of what the House's position to be on the bill at the moment. So the differences between this version you have in front of you and what the Senate passed in Senate Bill 366 is there are some technical changes. This version of the bill pushes implementation of the pilot program back to October 1, 2027 to give MVA a little more time. This version of the bill has a slightly different list of offenses which would trigger required participation in the program. This list is a little bit more focused on offenses related to speeding. There is a difference in terms of if an individual who's participating in the program violates a rule of the program, for how long the MVA would be able to remove them from the program. So under this version of the bill, it would be 10 days. Under the version that passed out of the Senate, it was 30 days. And then finally, the other difference is that this version has a slightly more specific reporting requirement for the MVA. And just to note, when it passed out of the Senate, it included some amendments which related to the ability of MVA to retain and share data under the program. Those are fully implemented into this version of the bill.
Senator Walsh-Reagan.
Thank you, Mr. Chairman. We pre-conferenced this bill with Senator Folden and Senator Love. This reflects the work product of that pre-conference. And so we think this is good to go.
Senator West.
Hear how much these devices are going to cost?
So MVA advises that that these devices, I think, cost, upwards of $100.
Oh, that's all?
That's correct. And
Well, you say upwards of $100. That could be $1 million.
no, I didn't mean to, I'm sorry, up to $100.
Up to $100.
I apologize. Just like for the alcohol interlock, there is an indigency program so that people who cannot afford it but still opt in have the ability to get assistance in doing so.
Okay, good, thank you.
Do you want to motion to adopt? Sorry, go ahead. Senator Folden.
The comparison between the House and the Senate version?
Yeah, so essentially that's when an individual is participating in the program and they violate some rule that MVA sets for the program, it's basically how long they could be removed and not kind of earning time towards their completion of the program. So this version of the bill was they'd be removed for 10 days.
Okay, so it doesn't have anything to do with how long it takes MVA to, like, notification process or anything?
No, so it's once it's been kind of adjudicated on MVA's end, basically how long that person is out of the program.
Okay, thank you.
All right, motions to adopt the amendment. It's been seconded. Now the bill's before you as amended. Motions for or favorable. Senator West.
So I'm looking online. I thought we'd passed this bill, and according to the website, it shows the bill has been passed by the Senate and referred to the House committee. So why are we amending a Senate bill, which is now in the House?
So we are amending the House bill, but this reflects basically what the House has proposed. So I guess what you're adopting is an amendment to the House bill that will make it identical to this.
This reprint is what the House is doing to our bill that we've already passed over. We are going to do the same as this on the House bill.
And the House bill is 212? I got it.
The House bill
Okay.
is 107, sorry.
I'm sorry, 107. Yes, all right, fine, thank you.
So is everyone okay? Being recorded in the affirmative on 107 with the amendment. Excellent. So House Bill 107 with the amendment passes unanimously. We're now going to Shamari. We're going to go on to House Bill 1181.
House Bill 1181 alters provisions related to children placed in out-of-home placements under a voluntary placement agreement with the local Department of Social Services in determining the reasonable efforts to preserve and reunify families. A child, parent, or legal guardian need not exhaust all home and community-based services. The Social Services Administration must consult with the Maryland Department of Health to provide specified annual training to local Department of Social Services staff. Annually, beginning July 1st, 2027, each LDSS must report specified information regarding voluntary placement agreements to the Department of Human Services, and annually, beginning September 1st, 2027, DHS must publish aggregated statewide data on its website. The bill alters the duties of the work group on children in unlicensed settings and pediatric hospital overstays and requires the work group to report its findings and recommendations by October 1st, 2026. By October 1st, 2029, DHS and MDH must submit a joint report that contains specified information concerning children placed in out-of-home placement under a voluntary placement agreement. There are no amendments.
Motions for a favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Yes. House Bill 1181 passes unanimously. Are we now going to go on to House Bill 330?
So we have to vote to reconsider.
Yeah.
Reconsider
All right,
the
I'm going to
vote
do
which
a,
passed.
so we've got an amendment for House Bill 330. So the motion is to reconsider the vote by which 330 passed. So for purposes of an amendment. Is everyone okay with that? All right, now 330 is before you. Council will explain.
So there's
There's a 330, House Bill 330 is before you now, subject to amendment. And there's an amendment that we're going to consider. Senator West, go ahead.
So 330 is the bill that expands the board of the Maryland Legal Service Corporation from 9 to 12. We passed that yesterday. I think Senator Folden was negative, everybody else was positive. So this is, we're going to reconsider that, and we're going to propose an amendment to that bill, right?
yes.
Good.
So the amendment in your packet, that's so there's an amendment in your packet. The amendment alters the appointment of the public defender. It requires advice and consent of the Senate for appointment of the public defender and reappointment. It requires that the Board of Trustees be reappointed with the advice and consent of the Senate. And it requires that the Board of Trustees be subject to the Open Meetings Act.
Move the amendment.
Senator West.
Before we do this, I just wanted to make sure, has this been coordinated in some way with the House? Are they aware that this is coming over in an amended state? Because I believe they passed Bill 330, where the House crossfire. It looks like this was all set to pass, and now we're going to throw a bit of a monkey wrench in the works if we adopt this amendment. I just want to make sure it's going to go through.
Yeah, no, I hear you. Let's hold the bill. We'll hold it for a day, and we'll talk about it later. The bill's not before us anymore. We're going to hold it.
Okay.
All right. We're going to go on. We're going to hold it. We're going to go on to Senator Senate Bill 433.
$497 first, or them together, because
Which one is 497?
there's an amendment on, this is the protective order.
497? Oh, yes, the Senate bill and the House bill. Yeah, yeah, we'll start with the Senate bill.
The House bill has amendments on it, and so,
We might have to conform the Senate version to the House version as well.
Yeah, yeah.
okay. So House Bill 497 generally extends from 7 to 14 days, the time during which a temporary protective order is in effect after service of the order. It similarly extends the time by which a final protective order hearing must be held following service of the temporary protective order as otherwise specified in statute. There is an amendment. The difference between the House bill and the Senate bill is that the House bill removed the provision which would allow a court to order respondent to pay certain losses or expenses incurred as a direct result of abuse.
Maury, what was the reasoning behind such a removal?
I'm not sure of the House's reasons for removing that, but there was testimony that, okay. We heard testimony on that was asking for that.
All right, what was the question?
Senator Folden had asked why the House.
Curious why where they struck out all the, everything, basically the whole bill except moving it from 7 to 14 days.
Did you guys?
Yeah, there was testimony that the protective order, I'm not sure why the House took the action, but there was testimony that we heard, I think from Judiciary, opposing those provisions.
So I guess at this point, my question is, what are we, the way it's written now, when I read this, it says that except as provided in this subtitle, or unless continued for good cause, the final protective order hearing shall be held no later, we have it currently, than 7 days, which is giving adjudication, but now we're moving it to 14 days after the respondent is served. That's what it says.
Go ahead. Go ahead, Sarah.
My apologies, I should not have spoken out. So if you look up on line 7.
I'm looking at the House bill
Right, on page 2.
on page 2.
So what happens, there's a difference between the practice and the way the statute is. So what happens is when the TPO is issued, temporary protective order is issued.
I've served them, I'm familiar.
Okay, then I don't need to explain this to you then.
No, that's why I'm asking, because what we're doing is, and before you had to have a hearing within 7 days after service.
So what happens?
Now we're expanding that to 14 days.
So
to
what
have a hearing.
happens is, it is when the temporary protective order is issued, there is a date for when they're supposed to come back with the final protective order, and that date is 7 days later. It is not 7 days from the date of service. It is actually, I understand, Senator, what's actually written, and what I'm telling you is what is going on. And so the purpose of this bill is to give more time to both the petitioners and the respondents, because service is not always made within the 7 days.
But this says days after service of the order. The service is when you actually give it to the respondent.
I understand, but the court always sets the hearing when they issue the TPO. And that hearing is always set 7 days later. It's on the TPO.
So the problem isn't expanding the window, it's that they're not doing it after service.
Right.
Because the law is clear that it's 7 days after service of the order, not at issuance of the order. So now we're creating a problem where we're expanding. This is a judge's issue. This is not a legislative issue. This is them issuing a TPO and then putting a date on it 7 days later instead of waiting for the return of service from law enforcement saying that they have served it and it's filing it 7 days later.
I hear you. I'm telling you what is happening, and the fact that we are so out of whack with the rest of the country in terms of when people have to go back in for the final protective order.
I understand the process, and I understand the dynamic that is seemingly out of control depending on what jurisdiction you're in. But what I'm simply pointing out is that as this is written, this language is very clear that we're now expanding this from 7 to 14 days after service of the after service of the order, not issuance of the order. If we're wanting to make it codifying to holding these judges and having a reportable timeline that they're going to be able to, they want to do it at the time they issue it, then it should say not more than 14 days after the issuance of the order, not service. That is a legalese, that is not, it's just a simple fix that we can fix here, or we can debate and still have it messed up when we put it out there because it's about the issuance, not the service. That's the issue. And I'm very familiar with what you're talking about, so I'm trying to help here. I'm trying to help. I don't normally do this, so Chris West is rubbing off on me on these last 5 days. It's wearing me out. The issuance is the important time frame because that's when they're stamping them with the date of the court proceeding. And then what you're trying to do is expand the service window so that they can get it to them before such date. Is that right? So then it would be seemingly proper that we would say that we would strike service and put issuance. I don't care about the timeline, the time frame, but if we leave it as service, then we've expanded it beyond law enforcement trying to track the person and serve the order, and now we've added 14 days onto the end of that before we're putting it in front of a judge by the law that's written. I mean, if the council wants to speak up to.
I'm going to say, we have a non-lawyer sitting 2 people away from me who I think has come up with an intelligent, legally intelligent idea, which is when the judge is asked to issue a temporary protective order, likes to schedule the final protective order hearing date. So the judge at the moment is on the horns of a dilemma because he doesn't know when the service is going to occur. So it makes sense to have the final hearing be scheduled by the judge for a period of time after he issues the order, not after it's served, because the judge has no idea when it's going to be served.
Well, that's kind of the point that Senator Love was making, right? So it's like if you issue something and then it's not served, or the person kind of dodges service, or the service is not effective for several days, then the order expires shortly thereafter. So let's say you have 7 days and it gets served on the 5th day, then it's only good for 2 more days.
But that's
If
why
you do-
that's why we're increasing it to 14 days.
Well,
Because
so
the assumption is the sheriff's going to get out there
that's a
within a
policy
couple of
choice,
days
but
and get it served.
the policy choice is, I mean, that's a policy choice, right? That's a discussion for policy, but the reasoning is that it would be 14 days or 7 days after you've been served, and then it's good. I understand that. I understand that. All right. So Senator James, then we'll come back.
I just wanted to ask a question. I have no idea what the answer is. Did anybody just go to the judiciary and say, hey, follow the law? I have no idea if, was the issue brought up in a constructive way at some point, and did we get a response? Or did anybody just try, or did anybody talk about it? I understand we have a bill, I'm not trying to waylay the bill. I'm just curious why we didn't talk to the judiciary, or did we? And they just said, this is better for us for other reasons. Does anybody know?
I support this if we do it at issuance. I just think it's really important because we want to capture the right window of time and have it legal standing, because it doesn't matter if I deliver it to them at midnight the night before the hearing. Once I serve it on them, they're bound to be there, or they face the determination by the judge. But at least they're notified. So that return of service is what's being missed here. There's a return that comes back.
Mr. Chair, as much as I hate to do this, I would like to hold this bill so we can get a little bit more information from the practitioners, because it sounds like the good senator from Frederick has a point, but I would like to dig into it a little bit more.
Who doesn't have a law?
Just saying.
Thank you.
All right, so it looks like we're going to hold that. We're now going to move on to Jamie. Are you ready with 1152?
Thank you, Mr. Chair. House Bill 1152 requires the Department of State Police to study and make recommendations on the employment and use of special police officers or SPOs, including the commissioning process, employment requirements, SPO operations, training and equipment, jurisdiction of SPOs, regulatory oversight to suspend or revoke the commission of SPOs. In conducting the study, DSP must survey and document the licensing of and regulatory requirements for SPOs and the equivalent in surrounding states, and analyze best practices for use of SPOs by public and private employers in the state and surrounding states by considering the number of SPOs in the state and surrounding states, mandated training for SPOs, including firearms training, impact of the use of SPOs on public safety and recorded complaints. In carrying out the study, DSP must consult with specified entities by December 1st, 2026. DSP must submit and report its findings and recommendations to the governor and the General Assembly. The bill takes effect July 1st, 2026.
Motions for a favorable, seconded, is everyone? 1152. All right, there's been a motion for a favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill, or House Bill 1152 passes unanimously. House Bill 405. 405.
House Bill 405 prohibits the governing documents of a condominium or homeowners association from prohibiting or unreasonably restricting the installation or authorization of installation of electric vehicle recharging equipment in common or limited common use parking spaces. The bill establishes that such installations are subject to the standard budgetary process of the condominium or HOA and requires the governing body to assess community parking capacity before installation or authorization. Additionally, the governing body of a condominium or HOA may grant a license renewable at the discretion of the governing body for up to 3 years on any common element necessary for equipment installation or electricity supply under the bill's provisions. The bill applies retroactively and must be applied to and interpreted to affect any covenant or restriction or provision in a declaration, bylaws, or rules recorded or adopted on or before the bill's effective date. There are no amendments.
Move favorable.
Motion's for favorable and seconded. You want to do a roll call? All right, you're down. Folding down.
Well, I mean, you just,
All right, so
hold on, so I gotta go back. Can you turn that off?
all right, House Bill 405 passes 9-2. All right, House Bill 493.
House Bill 493 alters the number of resident judges of the Circuit Court by adding 1 additional judgeship in St. Mary's County. The bill also creates 1 additional district court judgeship in District 11 to be appointed from Washington County.
There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yeah, let's move the Senate bill. What's the Senate? Go ahead and move the Senate bill. Motion's for favorable.
No.
Is everyone okay being recorded in the affirmative?
Hold on,
All right.
it's not on.
All right, we're going to bring back House Bill, or Senate Bill 433. Yeah, let's do the House Bill first. Sorry, what's the House cross file? What's the cross file? Summary for that one?
House Bill 497.
497. So House Bill 497. Put the Senate bill here, the House bill.
House Bill's next page.
It's not together. All right, where are we? Senator Love.
Thank you, Mr. Chair. It appears that we are all in agreement with the good senator across the way. You may never hear me say that again.
Just leave now. Just retire. It's good. He's out. He's gone. That's it. Mic drop. It's over.
Mic drop.
All right.
Yep. Somebody's going to be struck by lightning, and I'm not sure who it is. But so that we should be changing the language after the where it says for not more than now 14 days, and instead of after service of the order from the date of issuance of the order. And we'll need to do that in both places.
So just for the record, we've already adopted, or no, sorry, for HB 497, we're going to, should read, we're going to strike after service of the order and substitute for not more than 14 days after issuance of the order.
All you have to do is strike service and put issuance. It's interchangeable. That's really the part we're trying to get.
Strike service and substitute issuance. And then also on page 2, line 28, it'll read, the final protective order hearing shall be held no later than 14 days after the temporary protective order is issued.
On page 2, on line, what line?
28?
Yeah. Yes. Issue. You just strike everything else out.
Yes, and strike.
Textbook case of how we cross-party lines.
So you're going to read it? Just read it one more time for the record.
Okay, so starting on line 26, in page 2, it'll read, except as provided in section 4-505C of the subtitle or unless continued for good cause, the final protective order hearing shall be held no later than 14 days after the temporary protective order is issued.
You adopt the amendment?
Motion in favor.
All right, now the bill's before you as amended. Motions for favorable with the amendment, seconded. Is everyone okay being recorded in the affirmative? All right. House Bill 497 with the amendment passes unanimously. And then we're going to go on, do the same thing. We're going to bring up the Senate cross-file.
So it would just be the.
All right, so the motion to conform it to the House bill. Everyone's okay? All right. Senate Bill 433, as conformed to the House bill, passes unanimously. Okay. Yeah.
Thank you, Mr. Chair. House Bill 501 increases the penalties for existing sexual crimes involving a person in position of authority. The bill establishes a new sexual crime involving a person in position of authority subject to specified penalties, requires specified individuals to register as Tier 3 sex offenders, and designates a sexual offense by a person in position of authority as a qualifying crime for sexual solicitation of a minor. There is an amendment in your voting packet. This is Amendment HB 501/543-725/1. So getting into the amendment, the first changes are going to be in the reprint, page 6 of the reprint. In line 15, a first offense, so a basic offense, would retain the current 1-year penalty that applies to a first offense under the existing law. Offense involving a minor under the age of 13, this is line 19, would go to 10 years maximum sentence, and a second or subsequent violation, which is at line 23, would be 20 years maximum penalty. The next changes are going to be on page 7 of the reprint. This is the solicitation statute. So for background, the solicitation statute for a first offense carries a maximum period of imprisonment for 10 years for a first offense and 20 years for a second or subsequent offense. What the amendment does is it takes the new statute in its full form out of the solicitation statute, and it would apply to only those cases involving a victim that was under the age of 13 or a second or subsequent offense. And then that is the amendment.
All right, so to adopt the amendment, now the bill's before you as amended, Senator Folden.
Question about, I want to make sure I'm understanding that we already have the age is defined, but it's talking about in multiple places, like on page 6, line 3, it says is at least 6 years younger than the person in the position of authority.
You're talking about on the bill, Senator? Mm-hmm. Let's see. Right. So the way that the bill is set up, currently the position of authority statute exists under a statute that is fourth-degree sex offense, which actually includes a group of prohibited activities. So what this is actually doing is the bulk of the text of the bill is just deleting it from its current home in fourth-degree sex offense and moving it into a new section.
But I guess I'm asking is, what is the at least 6 years younger than the person in the position of authority?
Right. So
we've already have other defined parameters.
Right. So that's actually moving the definition. What you're reading there
is cut out of the other,
cut out
where
of
it was deleted.
Law, right?
Okay.
It's being recodified.
Okay. Yep. Yeah. That's all I needed. Thank you. Thank you, Mr. Chair.
The amendment's been adopted. Now the bill's before you as amended. Senator Love.
Thank you, Mr. Chair. So I see that for the solicitation, we're putting it to the minors, so under 13 or a previous conviction. We're limiting it to that. And then under 11701 of criminal procedure, tier 1 sex offender is only B. What about?
Right. So if you go on to the next page, Senator, C and D are included as a tier 3 sex offender. So tier 1 sex offense is the lowest tier of sex offender.
Okay.
So that would be the basic offense would be registration as a tier 1 sex offender.
Okay.
And then those either subsequent offenses or the particularly young victim would be a tier 3 sex offender.
Got it. Thank you.
A question for counsel. Can only a male violate this act?
I'm sorry?
Can only a male violate this? I'm looking at page 5, lines 20 through 22, and I'm wondering if I'm just not understanding in total.
So page 5, lines 20 through 22 of the bill, Senator?
Right.
Yeah, I don't know. I guess
It says a person in position of authority may not engage in vaginal intercourse with the minor. Who at the time of the vaginal intercourse, then it lists those things. So I'm just trying to understand, is this something that only a...
Sure. So I think I know the answer to your question, but I just want to make sure I'm on the right page. Are we working off of the bill at
I was
line
working
20?
off of the bill. That
Interlineated, okay. Page 5 at line 20.
I don't have the interlineated copy.
So I don't have the exact part of the text that you're looking at, but in a separate section, or a separate part of the prohibition, the prohibition applies not only to vaginal intercourse, but also a sexual act or sexual contact.
Okay.
Which would include.
That's, thank you.
Now the bill's before you as amended. Motions for favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? Okay. So House Bill 501 passes with the amendment unanimously. Now I'm going to move the Senate version, which is Senate Bill 407, which the motion would be to conform it to the House bill. Seconded. Is everyone okay being recorded in the affirmative? All right, excellent. Conforming. Yeah, so we've conformed. So Senate Bill 407 passes unanimously. All right, we're not going to go into just, sorry.
I don't want to move it yet. I have an amendment.
Oh, okay, yep. We can add that, yeah, absolutely. 407, we can add Senator Folden, Senator West. Yep, and Senator McKay. Senator James.
Okay.
All right, excellent. We're now going to go on to a departmental Josh at this House Bill 246.
240, okay, 246. House Bill 246 is a departmental bill that makes the registered owner of a Class G trailer vehicle that uses the Transportation Authority's facilities projects liable for the payment of any video toll assessed at the time of passage through a toll collection facility if the registered owner of the motor vehicle itself cannot be determined.
Motions for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Yep, it's House Bill 246.
That's the one where they want to be able to build a trailer if they can't see the tag on the back of the vehicle.
Yeah.
All right. So House Bill 246 passes 10-1. We're now going to go on to House Bill 351.
Or a state's attorney on receipt of a complaint of a federal agent misconduct to direct the Department of State Police to gather and securely retain as much identifying data as possible about the federal agent or federal agents who are subject of the misconduct complaint. A complainant may obtain access to the identifying digital data relevant to the complainant's complaint only pursuant to a court order issued in a 14 U.S.C. Section 1983 rights case or a criminal proceeding involving the subject of the federal agent misconduct complaint. We passed Senate Bill 346. It's not a direct cross-file. The House added on those provisions that I just described. Senate Bill 346 was the No Kings Act. The amendment, if we want to conform to the version that we passed, is to amend to conform, and that's the amendment that's in your packet, but there is also a second technical amendment.
So the piece that was just read out, so if you all remember the cross-file of this, well, not the cross-file technically. What was the Senate Bill?
346.
So this Senate Bill 346, which we passed out of here, if we conform, it will strip the provisions that you just heard, okay? So everything you just heard will not be included in the bill that we passed previously, which is Senate Bill 346. And then, so if you need a rehashing of that, we can do that.
Sure. So
But just so everyone understands what we're doing. So just actually, again, read the bill again, one more time, as introduced. Yeah.
yeah. So I just read the digital unmasking provisions, and I'll add in the synopsis to 346 as well. And so House Bill 351 authorizes the Office of the Attorney General or a state's attorney on receipt of a complaint of a federal agent misconduct to direct the Department of State Police to gather and securely retain as much identifying digital data as possible about the federal agent or federal agents who are the subject of the misconduct complaint. Complainant may obtain access to the identifying digital data relevant to the complainant's complaint only pursuant to a court order issued in 42 U.S.C. Section 1983 civil rights case or a criminal proceeding involving the subject of the federal agent misconduct complaint.
That's all out.
So that's now out.
And so what remains is that the bill would establish civil liability for an individual who, under color of law, deprives another of a right, a privilege, or an immunity secured by the U.S. Constitution, and it requires an action under the act to be filed within 5 years after the cause of action accrued.
Which was the Converse 1983 that we passed.
Already passed, yeah.
All right, so the motion is to, sorry, go ahead. That piece that he just read is out.
That leaves what?
That's out.
The digital imaging part?
All out.
That's the,
Is the digital imaging not in the,
It's not in the.
in the
It's
other?
not in the Converse 1983 that we passed.
Yeah.
It's not in there.
It's not in the bill that we passed,
So is this
and
bill
we're
gonna,
taking it out of the House bill that they passed.
Oh.
they're gonna be similar to the bill
It's gonna
we
be
passed, the
exactly
No
the same
Kings
bill.
Act.
Well,
With one technical, with a
amendment.
With a technical note. Fine. I'm good with that. Whatever that
Senator
is.
West.
Excuse me. So the No Kings Act was hugely unconstitutional. This makes it even more constitutional. So we're going to take out the even more constitutional stuff and leave us just with the original unconstitutional bill, correct?
Do you think, I mean, you think,
Unless you want to stingray law
you
enforcement
think
agents.
warrantless collection on law enforcement is, okay. And warehousing that information just from a citizen complaint is, okay. So anyway.
Don't let him fix
Yeah. It's up to you. I mean, we can roll with that. You want to roll with that? We can roll with that.
No, I'm happy with the amendment to take the other stuff out. But we should vote on the underlying bill.
Okay. So the first thing is to conform, and you want to mimic the vote, record in the same posture that you had the original.
Yeah, but you said it's not in the same posture.
We're
That's what we're doing.
we're conforming it to the Senate. All right, now, hold on. So that's basically West is down, Folden was down. You're up or down? Up on the, okay. So now,
Are West and Folden
down.
down on adopting the amendment?
They don't care. Jesus. All right, got it. So now the bill's conformed, but now there's an amendment that the council will discuss.
amendment that needs to be made to conform to the version that's going to be passed or to pass by the House. And so when we first got the bill, they weren't cross files. The House added the digital unmasking or added No Kings onto their digital unmasking bill. And so there was no cross file. And in attempting to get everything to match, there was a strikeout that happened on page 32702. And this is line 23. And so 2702 reads, an aggrieved party or the office of the Attorney General may bring an action against a covered officer who, under color of law, deprives the aggrieved party of a right, a privilege, or an immunity secured under the law. And so the strikeout or causes or allows the aggrieved party to be deprived, that was intended to remain. And that was my understanding of the intent of the committee at the time. And so that should be added back in.
What page?
This is page 2 of the amendment reprint,
21 through
23 through 24.
So moved.
Yeah.
Seconded. Is everyone okay with the amendment?
Why were you saying that they struck that and now that it was an unintentional, an inadvertent strike?
We struck it accidentally in the drafting process.
Because they
Of
were
of the Senate bill.
But we're on the Senate bill, we're on this.
I know, we are fixing it on the House bill, and they are going to fix it on the Senate bill. So everyone's aligned.
Now the bill is before you as amended and conformed. Motions for or favorable. Everyone's going to be recorded in their initial posture, so Senator West is down, Senator Folden's down, Senator McKay's down.
Are we changing the title of it too?
All right. All right, we voted House Bill 330 unanimously. Can we just record that same vote? House Bill 330 was voted unanimously.
And there was an amendment yesterday, I believe. Right, Shamari? Was there an amendment on 330 yesterday?
There was not.
There was no amendment on 330 yesterday.
All right, so,
Positive. Okay.
yeah. Is everyone, yeah, we'll find another one.
House
Okay.
Bill, you said House Bill 330,
Yes,
so that was Senate Bill 252? I was against.
yeah, you were down, that's right. But then we reconsidered and now we're voting it now clean. Okay. Is everyone okay just being recorded in the same? Yeah. We'll find another vehicle. House Bill 308.
House Bill 308 modifies the definition of principal office in the Corporations and Associations article by including an address supplied by a commercial mail receiving agency that a Maryland corporation, LLC, LLP, or limited partnership has a valid commercial mail receiving agreement with in accordance with Postal Service regulations. There is an amendment in your packet which was suggested by the Bar Association. It is number 133120/1. This clarifies that the address must be in the state of Maryland, and it removes the requirement for the commercial mail receiving agency to provide certain information to SSTAT or a law enforcement agency on request.
All right, so okay, adopt the amendment. All right, now the bill's before you as amended. No. All right, now the bill's before you as amended. What's your pleasure? Motion for a favorable with the amendment, House Bill 308. Is everyone okay being recorded in the affirmative? House Bill 308 with the amendment passes unanimously. All right, we've got House, Shamari, that's you. No, he's looking for his amendment packet. Charles, we're gonna come back to it real quick.
There it is. I've got it.
Josh, can we do, let's do House Bill 552.
House Bill 552 is a virtual cross-file of Senate Bill 776. It establishes the Commission on the House of Reformation and Instruction for Colored Children to be staffed by the Office of the Attorney General. The purpose of the commission is to research the history, operations, and resident deaths at the house, to provide a complete and public accounting of the children who died and were buried on the grounds of the house, to promote healing and reconciliation through truth-telling, acknowledgement, and recommendations for systemic reform, and to ensure descendant and community voice throughout the investigation and reconciliation process. The commission must submit its initial report and its final report by December 1, 2027, and December 1, 2029, respectively. I don't think there is an amendment in your packet, but this bill is just slightly different from the Senate bill, and I understand the difference was not intentional. The House just wasn't working off the most recent version of the Senate bill. There's two changes that would need to be made to conform it to the Senate bill. First, there's a provision in the Senate bill that requires, to the extent practicable and consistent with state and federal law, that the commission contract with Maryland institutions and historically black colleges and universities. And there's also a provision that clarifies some of the qualifications of a couple of the commission members. So I believe the motion would be to conform to the Senate bill.
The motion's conform. The Senate bill, I believe, is either on second reader or has passed third reader in the House already, so it's conformed to the Senate bill. Is everyone okay with that? All right. Motions for a fee. Everyone's, okay, so it passes unanimously. All right, we're going to pull up House Bill 315, and then Shamari just walk us through what the amendment is, and then the next steps we have to reconsider the vote by which it passed. So go ahead and walk us through.
So House Bill 315, we already adopted the amendments, or an amendment. And so the amendment to conform to the Senate bill would need to include the positive rental history reporting framework that we passed. And so the motion now is to amend to conform, and then there is a second amendment.
So first,
Consider.
Yep. So is everyone okay with reconsidering the vote? Motion passed. All right, excellent. Now there's an amendment before you. There's motions for.
Is the amendment in the packet?
Yes, the amendment is in the packet, Amendment 543220/1.
All right. The amendment has been moved. It's been seconded. Now the bill is before you as amended.
And so that amendment incorporates all the changes. One, conforming to the Senate bill, and it strikes language that was a result of some conversations in committee. And that language is on subsection E. I can find the page.
One second.
So if you're looking at the reprint of Amendment 543220, yes. So the amendment before you strikes and utilities from would have been in line 17 on page 3 of 4 of the reprint. And so it now reads, subsection E reads, notwithstanding subsection B of this section, a landlord or residential rental property may require verification that a tenant has sufficient income to pay the portion of rent not covered by the income-based housing subsidy using an income to tenant's portion of rent ratio that is substantially equivalent to the ratio used by the landlord for non-subsidized tenants. And so Senator McKay's amendment is also incorporated into this reprint, and that part is on the same page. If you look at line 27, a landlord or residential rental property may refuse to rent to a a landlord of residential rental property may refuse to rent to a prospective tenant who pays rent with the assistance of an income-based housing subsidy on the basis of any commercially reasonable and non-discriminatory use of a reference from a previous or current landlord of the tenant, or 2, the tenant's history of violating lease, failing to pay utilities, that's new language, creating a nuisance, or damaging property.
Senator West.
I just wanted to make sure that these amendments were here. So it sounds like they're correct. I'm looking towards Mr. Enton to see if he nods his head yes.
All right, Senator James.
Thank you. I'm having trouble hearing. I don't think I'm going deaf either, so I think we just have a vocalization problem here. So I hope people will speak up a little more. So I didn't hear almost anything that you said, and I tried. So I think we're amending the House bill to look more like the Senate bill, and I think we've done some stuff to improve the Senate bill by taking some language from Senator McKay, which looks like it's pretty good.
Yes, so
Is that generally what we just did?
The Senate
And I
bill-
can speak in this level so you can hear me.
Yep. So the
Okay.
Senate bill we passed had a provision that allowed the landlord to take into account the portion of rent and utilities not covered by a housing subsidy.
Right.
And so we're essentially replacing that and utilities language
Right.
with Senator McKay's language, which allows a landlord of residential property to refuse to rent based on a history of failing to pay utilities.
But not failing to pay, but not looking at the unsubsidized, like, let's say you have a 70% subsidy, but you fall down on the 30% that's on your, that you're responsible for. How do we handle that?
So under the bill as amended,
Yeah.
the landlord can only look at the portion of rent not covered by the
Right.
subsidy.
Yeah, not covered. And now we've thrown in also utilities if they're not covered. Is that correct? Is that what we're doing?
And so, no, not exactly.
Wow.
And so the utilities can be used, the history of failing to pay utilities can be used as a basis for denial.
We're saying the same thing, I think, there.
Okay.
I think you're right. Yes, the utility. Now, sometimes utilities might be covered. That got into a very weird conversation where nobody seemed to know. But the point is, if they're not covered, as Senator McKay, which many times, oftentimes they're not, because that is such a fluctuating thing. We can now look at that along with the other language. And now, can I ask you, with this amendment, because you and I were sort of on the same page with some worry, because we both are small landlords, is this where you think the bill is much improved?
Yes, absolutely.
Okay, and I can't, and I had, okay, because I think I may, Sandy, I don't know if you could tell me, I may have voted against the bill, but I think with these amendments,
I voted against or,
yes, okay.
but
With these
with these amendments, plan to vote for both of them when they get to
Very
the
good.
floor.
Congratulations, all of you. Thank you. Okay, very helpful.
Excellent. Now the bills before you as amended. The motion is for or favorable. It's been seconded. Is everyone okay being recorded in the affirmative? House Bill 315 with the amendments passes unanimously. We're now going to go back to Senator Sidnor, which House Bill 573.
House Bill 573 authorizes the Department of Housing and Community Development to adopt certain regulations related to affirmatively furthering fair housing, providing that certain discriminatory housing practice may be committed without intent. It prohibits a person from acting a certain manner that has a discriminatory effect and provides that certain conduct necessary to achieve certain non-discriminatory interests does not constitute a certain violation. So the House bill came to us clean. The Senate bill, we made several amendments. The Senate bill contains non-codified text, clarifying that the bill is not intended to abrogate existing case law or regulation. There's language stricken from the definition of discriminatory effects. If you look at the bottom of page 3 of the reprints. So the Senate bill struck or creates, increases, reinforces, or perpetuates segregated housing patterns. And then on page 4, lines 5 and 15, the Senate bill struck regardless of intent in both instances. And then if you look on page 5, if you look in subsection or section C and paragraph 2, we replaced an and with an or. And then again in line 10, an and with an or. And this amendment also incorporates another amendment, and that's on page 4, line 14. This section does not apply to practices regulated under Title VII of the insurance article. So this is, that does not conform to the Senate. We did not add that last provision.
Can you explain the high level, Senator Sidnor, I know you're going to talk about it, but high level logistics, just put asking in language what the bill does.
And so the bill now, so I'll start with page 5, that and or, there was some discussion about whether that actually did anything or was changing case law. But I think we have an uncodified provision that says we're not intending to abrogate or supersede any existing law. The Code of Federal Regulations contains similar language. It says in determining whether a person has violated prohibition in subsection B, it says the action was necessary to achieve one or more substantial, legitimate, non-discriminatory interests. And so it doesn't include the conjunctive or the disjunctive. The case law kind of uses different terminology. Sometimes it says legitimate business interest, substantial interest, and so we amended the Senate version to reflect the disjunctive as opposed to the conjunctive. And there was a request from some of the stakeholders to change that. And then the definition, discriminatory effects, that's on page 3. The definition in the bill as it came, as it came in, that was also taken directly from the Code of Federal Regulations, and that striking of language was also a result of discussions with some stakeholders and concessions made.
All right, Senator Sidnor.
Oh. Thank you. My druthers, again, given the uncodified language that we spoke of, would be to pass the House version unamended. And I would like to speak to some of the things in the amendment. First, in talking about the insurance industry attempting to be removed from the provision, this is something that I think the industry as a whole has been trying to do for a number of decades, and we have case law that says that they are subject to disparate impact theory, and it applies to insurers. So if we were to exclude them, we're making we're giving them a pass that they don't get at the federal level. So I would push back and ask us not to accept that. In addition, as counsel noted, again, when we were dealing with the language substantial, legitimate, or non-discriminatory interest, it was an error on my part in kind of thinking about what we were trying to do. what I'd prefer that we do is in accepting what the House did, the language is most similar to 24 CFR 100.500B1, which states it's a substantial, legitimate, non-discriminatory interest. We can keep the and, or we could get rid of and or, and just state substantial, legitimate, non-discriminatory interest. So.
Senator Love.
Thank you, Mr. Chair. I agree with my colleague that we should parallel the language, either keep the and or take it out entirely. I also don't know why we would exempt anybody. This seems very odd. I haven't heard any reason to take them out, and I'm very concerned about the impact that that would have. So I agree with my colleague.
Move the House bill favorable.
It has the uncodified court language, or
If we want to put the uncodified language in, that's fine. It's my understanding that the House, they took the Senate version and stripped everything that we did, but for the uncodified language in it.
the uncodified language shows our intent and match every law.
So that's fine.
Yep. So the bill is before the committee unamended, and so there's a motion for an amendment to add uncodified provision, and so it would read Section 2, and be it further enacted that it is the intent of the General Assembly that this act be construed to be consistent with the analysis and holding of the U.S. Supreme Court and Texas Department of Housing and Community Affairs v. Inclusive Communities Project Incorporated, 576 U.S. 519, 2015, and 78 FR 11460 and 24 CFR 100.500 of the Federal Register, and 2, not be construed to abrogate the holding of the Supreme Court of Maryland in Hare v. David S. Brown Enterprises, Ltd., 491 MD 653, 2025.
Motion to adopt the amendment. All right, seconded. Is everyone okay with that? All right, now the bill's before you as amended. Motion's been for favorable, it's been seconded. Do you want to just do a roll call, or is everyone okay? Okay, so just do a roll call then, go ahead.
Vice Chair Waldstreicher.
Yes, as amended.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden.
Yes.
Senator James.
No.
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
Yes.
Senator Charles.
Yes.
Chairman Smith.
Yes. I think that's the first time your little mini-me made an appearance on camera, man. I don't know. We're now going to go on to House Bill 658.
So JPR was secondary in this bill. So this bill, Senate Bill 658, codifies the Community Forensic Aftercare Program within the Maryland Department of Health to monitor persons committed as not criminally responsible who are on conditional release and individuals with mental illness or intellectual disability who are required to be monitored under statutory provisions pertaining to individuals found to be NCR or incompetent to stand trial. The bill also specifies new requirements for the program. The bill codifies CFAP's existing board named the Community Monitoring Board under the bill, consisting of licensed healthcare providers to make recommendations and decisions relating to conditional release and out-of-state travel requests as specified. MDH must adopt regulations to carry out the bill. There is an amendment, and the amendment prohibits a court from requiring or authorizing a program monitor to make clinical decisions. It clarifies that program monitors may only make monitoring decision, and clarifies that a court order may not be construed to require or authorize a program monitor to make clinical decisions, regardless of the order's issuance date.
All right, so I'm going to move the amendment and then discuss it. All right, now the bill's before you is amended. Senator Henson.
I don't know that I've ever seen in the law to say a court order may not be construed. So we're taking existing court orders and we are, through the code, interpreting an existing court order to make it say something different. How does that, can't we not make ex post facto laws? Don't we have separation of powers? Don't we have, it just feels like there's a number of reasons why putting into the code that an existing court order cannot be construed to do what it does.
Yeah, I think that's probably correct. I haven't seen that elsewhere in the code. I'd have to get back to you to look for an example.
Okay.
We're going to assign some folks. Let's sit down. Let's you, me, council sit down. Senator Love, go ahead.
Thank you, Mr. Chair. This is the cross-file of a bill we've already passed out. So is it now different?
Yes.
Okay, thank you.
All right, we'll hold it a day. We'll come back tomorrow to it. All right. All right, let's go on to House Bill 85. House Bill 85.
House Bill 85 authorizes a Maryland non-stock corporation to convert to a cooperative limited equity housing corporation and establishes specified procedures and requirements for the conversion. The bill prohibits a county or municipality from imposing restrictions on a CLEHC, including restricting the sale of residential rental facilities to a Maryland non-stock corporation that plans to convert to a CLEHC. The Department of Housing and Community Development may establish 1, additional rights and requirements for a CLEHC as specified, and 2, a program to provide grants to Maryland non-stock corporations to promote the establishment of CLEHCs. The bill takes effect October 1st, 2027. There is an amendment in your packet. I'm sorry, that amendment would be to the Senate bill. I just described the House bill as we have it. SB 511 is the cross file, and that amendment that's in your packet would conform to the House bill I just described. 511.
So we could, this is the last bill. All right, so you move favorable on the House bill, and then we'll bring up the Senate bill and conform it if that's the will of the committee. All right. Yeah, this is my Senate bill, but it'll go to rules, and we'll try to get it out, but. No, I had it before last year. All right, so then that bill, House Bill 85 passes unanimously. Then we're going to bring up House Bill, or Senate Bill 511, which is the cross-file. I'd like to conform it to the House bill we just passed unanimously. Is everyone okay?
And that's Amendment 783521.
Yeah.
Larry?
Yes.
All right, hold on 1 second, 1 second. All right. House Bill 426.
House Bill 426, on the filing of a petition for guardianship of the property of an alleged disabled person, authorizes a party to the guardianship to file a request for the stay of specified civil actions or proceedings with the court presiding over the civil action or proceeding. The party to the guardianship must give specified notice to the parties to the civil action and notify the court granting the stay and any party to the action. If a guardian is appointed or the petition is denied, dismissed, or withdrawn, a stay must automatically be lifted if a guardian is appointed or the petition is denied, and a stay may not remain in effect for more than 90 days after the filing of the petition. The bill applies prospectively and may not be applied or interpreted to have any effects on or application to any petition for the guardianship of the property of an alleged disabled person filed before the bill's effective date. There is an amendment in your packet. That's Amendment 283627. This amendment would give a court discretion to extend the stay upon good cause.
All right, so move here on the amendment. Now the bill is before you as amended. Senator Love.
Thank you, Mr. Chair. I'm just trying to make sure I understand this bill. So in looking through some of the things that are listed, let's say, for example, there's an action for failure to pay rent under 8-401 of the real property article. Then someone comes in alleging that the tenant is disabled and asks to be the guardian of the property and to stay the proceedings. Is that correct? Okay, so are there parameters somewhere around who can be the person petitioning for guardianship of the property? And it says an alleged person is, it's an alleged disabled person. What has to be in that allegation?
And so I'm not super familiar with the guardianship proceeding, but that would be a separate proceeding started by someone who's incapacitated and unable to make decisions or control their property on their own. And so in that proceeding, if someone is making that petition, then they can, under the bill, be able to request the stay in the listed proceedings.
Okay, so there's already a proceeding going on alleging somebody is disabled?
And so the bill says on the filing of the petition, so my reading of that is that it would require the proceeding to be initiated with the filing.
Okay, thank you.
Senator James.
Responding to Senator Love, I feel like, didn't we pass a bill? I thought it was maybe this one, but where there was another issue and we allowed a finite group of people to intercede and petition to assist some people. I don't know if they were stuck in the hospital, but it was beneficial. But we were careful the way we drafted it to make sure it wasn't just man on the street could come in and do this, but they came in sort of a defined group with a defined purpose. Does that ring a bell? Were you here there for that, Senator Love? Might have been 2 years ago. You remember that? Okay, is that how?
I vaguely remember the bill. I can try to find that. I do remember that.
Do you remember that?
Yeah.
I don't know if that would help Bill some. All right.
Senator Henson.
add, Mr. Chair, that this doesn't change any of the carefully laid out rules for guardianship and how a guardian is selected by the court. It simply, it operates similar to the way a bankruptcy proceeding would. If a person has filed for bankruptcy protection, then the proceedings are stayed until they're at the end of their bankruptcy and everything is discharged or the case is dismissed. So this would similarly say if a person is in the process of petitioning for guardianship, they would have to allow the guardianship petition to be adjudicated by the court, then they could come back and they would resume the proceeding. So the value of this bill is just to receive a stay so that the person that is under a disability has the ability to have a guardian appointed so that they are having a person who can participate in the legal process on their behalf and they're not required to.
Finding good people to help the individuals that have a disability. It's one thing to, you know, so I thought maybe that's why we were trying to, these are vulnerable people, and a lot of people want to take a pass, even family members, so I thought we were trying to figure out a way to get a certain type of person to assist with this particular process, but that's really a limited role, but that's not.
That's right. This wouldn't disrupt any of that.
All right, thank you.
Now the bill's before you as amended. This motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. House Bill 426 passes unanimously. We're good to go. See you on the floor. Thanks, Shanika. Thank you.